The name of the case was Kristen Elliott versus Connect the Dots. Kristen, at the time, was 23 years old. She was a champion gymnast and cheerleader, competitive cheerleader. So she got this audition notice, and they were looking for experienced cheerleaders to do like a little short, they call it a fashion film. They were practicing at the last minute, as directors will, said, hey, I have an idea. Why don't you guys do a stunt? And they weren't set up for stunts. It wasn't anticipated. The production company didn't have any kind of equipment for safety or any kind of coach that knew about how to do cheerleading stunts. The person in charge was a choreographer, just a dancer. And the problem was that producer is the one responsible for safety. And specifically, they're supposed to be there when they're doing any kind of physical activity. And she left to take a phone call. She was gone for an hour. And so the stunt went forward, and our client was what's called the flyer. She was the one up in the air being held up by the other cheerleaders, and there was a mistake made, and she fell and she shattered her elbow. The injury destroyed her radial head of her elbow, which is one of the two parts that make up the elbow joint, and it couldn't be repaired. It had to be replaced with a replacement one made out of metal. And it started grinding away over the next year until she had all kinds of shards of metal fragments. And she got to the point where she couldn't even use her arm. And they had to go in surgically and remove the radial head. So she was left with an arm that was missing the radial head. She's already got arthritis in the joint, and that's going to progress and get worse. And it'll be so painful, she'll have to have an elbow replacement. The producer said, if I had been there, I would have stopped it. So really, the liability aspect of the case, I thought was pretty clear, because if you're supposed to be there and you're not, and you would have stopped something from happening, well, clearly she wouldn't have been injured if she'd stopped it, but she didn't stop it because she wasn't there. So it was a significant injury, but she's done doing the gymnastics and the flip-flops and backflips and all that kind of stuff, because she can't put any kind of real load on that arm. They tried to get around that, but the owner of the company testified, well, we did production services, and we provided little pieces of what producers do, but we weren't the producer, even though every shred of paper said they're the producer. I was blown away when he said we didn't produce the film. And I think the jury was pretty blown away too, because they were like, they didn't understand how this guy could say he wasn't producing the film. We also had an expert witness, and he said, of course, they were the producer, and of course they were responsible for making sure that everything is being done safely. We had a doctor, a surgeon, an orthopedic surgeon who specializes in arm, hand, elbow surgeries. We had an occupational therapist who did a lot of testing to really quantify her deficits in her dominant arm. And even though she can use it, she's a personal trainer, and she does things with the arm. It's not like it's a useless appendage. She can use it, but she can't lift over a certain amount of weight. She does certain things. 50% of her cartilage is gone. And we had MotionLit do animations, not only of the accident to recreate the accident, but we also had animations of the two surgeries she had. That makes a really big impact on a jury, as opposed to some illustrations, still pictures and stuff, or just trying to have a doctor explain it. The animations really driving home what happened to her. And she was going to need, probably over the next 60 years, 3 different types of operations. They gave over $2.1 million, which is pretty significant for a person who is not incapacitated. She had this injury, and there was a lot of video and from surveillance that would really, really hurt the damages, the pain and suffering, if a jury thought, well, she's functioning really well. But they got it, and I really credit MotionLit and their animations for that. Their first offer, before we even filed suit, was $75,000. They said, we don't have any liability here. It's not our fault. She did a stunt, she fell, she got hurt, she knows the risks, that's it. We went to mediation, and they stayed at $75,000. We had no settlement discussions. The case dragged on for a few years. Just before trial, they made a 998 offer for $400,000, which we did not take. We had made $1 million 998 offer. I got no response. The lawyer kept telling me all through the case, I don't see liability. What did we do wrong? If I can't convince you of it, I guess I'll just have to convince a jury. I didn't expect to get more than $1 million on this case. I mean, they might have said, you know, she looks pretty good. I felt that the case was worth in that area. So the fact that we got $2.3 million for pain and suffering past and future, I have to attribute it to the animations. If you don't have those, you're just not going to get that kind of an award. MotionLit does an excellent job. And if you have a case that has significant injuries, you shouldn't hesitate to use them. When you have these animations, it shows the defense you mean business. It shows the defense you are going to fight this case. If you do it early on and you show them the animations that you have, it'll help you settle the case. But I don't think that any lawyer should be going into any kind of a case with significant damages without MotionLit. I won't handle a significant case without having them involved in it. It's invaluable. I'm addicted to MotionLit. If you have a big case, you're not going to get those big judgments unless you use some sort of demonstrative evidence, and MotionLit's the best.